All rise. Before this meeting comes down session, the Honorable Tony F. Graff Jr. presides.
Please be seated. Court is now in session. Counsel, if you could enter your appearances, please.
Your Honor, Christopher Ballard, Ryan McBride, Chad Grunander, and Lauren Hunt on behalf of the state.
Good afternoon.
Good afternoon, Your Honor. Kathy Nestor, excuse me, Richard Novak, Stacy Visser on behalf of Mr. Robinson.
Good afternoon.
Good afternoon, Your Honor. Jeff Hunt and David Ryman appearing on behalf of the media interveners that are identified in our motion papers.
Good afternoon.
Michael Judd, Your Honor, Parsons, Bailey, and Latimer, on behalf of another set of media interveners also identified in the briefs.
Good afternoon, and I recognize Mr. Robinson in the courtroom as well. Good afternoon. And for the benefit of the record, calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, as we're moving forward today, I want to give an overview of what we anticipate doing. And it comes down, we're addressing three issues. The first is the October 14th, 2025 audio recording of the closed hearing and the October 24th, 2025 transcript of that hearing. The second is the state's motion to amend or clarify the publicity order, commonly known or referred to as the gag order. And finally, the motion for limited intervention and request for notice of motions to close, seal, or reclassify, and which has been filed by the media organizations and by counsel who are present today. So as we begin, the first part is we'll begin by addressing the October 14th audio recording and the October 24th transcript. This portion of the hearing will be closed so that I may hear from the parties regarding which portions of the recording the record should remain sealed. All members of the public and the press will be excused, and the hearing will not be broadcast. This is because I need to hear what should or should not be sealed or protected, and it would not benefit to have everyone listen to what should be sealed. And so after I've heard argument, we will invite all parties or the public and the media to come back in, and the hearing will resume transmission. We will then take up the motion for limited intervention, followed by the state's motion to amend or clarify the publicity order. These portions, the last two portions, will be open to the public and to the press. After hearing argument on all three matters, I will take a brief recess and then return to issue my ruling today. We will then stand in recess. So at this point, we'll go ahead and excuse the public and the media, and it is the court's order that transmission be terminated temporarily.
Your Honor, we have one request with respect to the closed hearing. May I be heard on that?
Yes, counsel.
Thank you. Richard Novak for Mr. Robinson. Mr. Robinson has some immediate family members who are present, his father, his mother, and his brother, and we would ask the court to permit them to remain in the courtroom during the closed portion of the hearing.
To the state.
My only concern with that, Your Honor, is that we're going to be talking about court security measures. And I don't know that we'll have to go into a lot of detail about that, but I do have concerns about those issues being discussed in public.
All right. Mr. Novak, do you have authority that supports allowing them to remain in a closed hearing?
No, I think it's subject to the court's discretion to decide who is and is not an appropriate member of the public. I think they have a unique relationship with Mr. Robinson, and they would certainly abide by any orders the court makes concerning disclosure of what is discussed in closed session. But obviously, it's up to the court.
Thank you, Mr. Novak. I'm going to rule that they will be excluded as well. It is just given the nature and the sensitivity of it. I believe it is appropriate to treat all parties in the public equally, though I do recognize their relationship with Mr. Robinson. Thank you for your request. All right, we will go into the closed session. Thank you.
On with us, your thoughts and reactions so far?
Well, my first reaction is looking into the courtroom and seeing what's happening. Again, talking about Robinson, it's disgusting. He's a true sociopath. It's someone who has absolutely no empathy. They have no remorse. They have no conscience. He killed somebody. He doesn't care. He's smiling. But again, that's not going to serve well. You know, when the trial comes to pass and the death penalty is on the table, again, jurors will not be okay with that. The other thing that I think is very important to understand is that working with these victims, I know myself when I was an FBI agent, I wanted a victim-centered approach. Erica Kirk and those in her surrounding sphere, her family, her loved ones, Turning Point family, they are the victims of this. And frankly, the American people who have had to watch this absolute catastrophic tragedy and evil live on television. I mean, it's disgusting, it's heinous, but she has a right to know. And I do think it's very important in this process that you are working closely with the victim, and I assure you that they are. She deserves to know what is going to happen. She didn't wake up one day and become a legal expert and a law enforcement expert. She is the victim of this most heinous crime. And again, God bless her, God bless her family. And I do appreciate that there are people that will step up to the line and will hold her hand and walk her through this process, as that is what she deserves. There's several other things that come to my mind in this trial, but it does come down to the judge's decision. But the conspiracy theories are despicable, they are disgusting, and you are profiting off of someone who has been murdered. And that is wrong, that is sick. And if you think that you're helping justice to be served, you are wrong. You are doing no favors for the prosecution team. There are solid law enforcement officers on these investigations. Trust that they are doing the right thing for the right reason. Look, I come from the FBI. I understand why people are in a position where they do not always trust the criminal justice system because of things that we have seen in our country. But rest assured, on this investigation, no stone will be left unturned. All eyes are on this, and there will be no mistakes made. And so please do not take the liberty to go and make up and fill in the gaps where you do not have answers. It is inappropriate. You are not helping things. You are making things worse. And if you want justice to be served, you need to let the process work the way that it should and stop putting these lies into people's minds, because you are hurting people. And most of all, you are hurting Erica Kirk, her family, and her loved ones. It is unacceptable. It cannot be tolerated. And anyone that has a clear conscience about making money and creating clickbait, that is sick.
Yeah, Nicole, I read some of your comments earlier about the idea of cameras in this courtroom. At the moment, there is a camera in the courtroom, though it's not turned on right now because they're in a closed hearing. And you thought that to some degree, maybe even to a large degree, it could be a two-edged sword. It could work well in terms of public transparency, but it could also work against the prosecutors.
I agree with that statement, because that is how I feel. Again, I come from the federal system where there is no media permitted into the courtroom as far as cameras, no electronic devices, no phones. But, individuals are invited into the courtroom. You can take your pen and paper, but there's no electronic devices that are permitted. And the federal system has worked well for trials. But again, I am always focused, for me personally, the victim-centered approach. And if this is what Erica Kirk wants, and this is best for her and her desires, obviously the judge will make the ultimate decision. But I do believe that he will take into consideration, first and foremost, her interest and also that of the public. Again, this was a political assassination. It does affect everybody. But I do believe that this judge is very deliberate. He is very calm. He is very calculated. And I think he has a very good head on his shoulders. I think he will run a very good trial. And I do believe that ultimately you want it to be fair. The last thing you want in law enforcement is to have to go back and retry the case. That's not what you want. And so you don't want the defense to have any wiggle room to say, you know what, that wasn't fair. We're going to ask for a mistrial. You don't want that. Make it fair from the get-go. Do it once, do it right, and put this person behind bars. And if necessary, and they seek the death penalty, that is what he should get.
Yeah, I remember Erica Kirk sharing her thoughts on cameras in the courtroom when she was on with Jesse Waters in early November. And she said, there were cameras all over my husband when he was murdered. There have been cameras all over my friends and family in mourning. There have been cameras all over me, analyzing my every move, analyzing my smile, my every tear. We deserve to have cameras in there, she said. Let everyone see what true evil is. Nicole, we're going to take a quick break here as we do await those cameras back in the courtroom. We appreciate you joining us.
Let's bring in Trey Gowdy, Fox News contributor and former South Carolina congressman, for more on this. I know that you're just a simple country lawyer, Trey, but what do you make of what's going on and what now is the biggest legal stage in America?
Yeah, I would say a couple of things. You know, cameras aren't allowed at all in federal court, and for the most part, we have a lot of confidence in the outcome. So I would not conflate public with the presence of cameras. This trial is going to be public. Anyone who wants to go watch it can. That's a separate issue from whether or not to allow cameras. And I can tell you the judge is not worried about the American people. He's not even primarily worried about the defendant. He's worried about the jury. He wants to protect the anonymity of the jury. And can you trust the television camera operators to protect those 12 people and their anonymity? The other thing I would say to Sandra is stop trying to figure out the mind of someone who is capable of doing what Tyler Robinson did. You will never be able to understand the mind of someone who is capable of scalding their children to death, of drowning their children, of bludgeoning an elderly couple to death, all of which I saw in my career. Be mindful of this, though. That little smirk you see on Tyler Robinson's face, you may see it again in the penalty phase of a death penalty trial where the absence of remorse is relevant. It's not relevant in the guilt phase, but in the sentencing phase, you can show that little smirk to the jury, and I guarantee you the jury's reaction will be the same as yours, and it won't be good for Tyler Robinson.
Wow. Yeah. Just incredibly difficult for all of us who are taking that in. It's happening. We've got the video playing there. Obviously, we don't have a view in the courtroom right now. But Trey, take us through what may be happening right now. We're all sort of waiting for the cameras to open back up in the room when the judge is allowed to do so. I mean, this is the first time, I reiterate, that we are able to see him in that courtroom, Trey. And this is a big moment for the country who remembers that day all too well 3 months ago, that heinous, heinous murder that played out before people live there on the scene, and for all of us who learned in the minutes and hours that followed.
Yeah, and that's the exact same guy you're seeing right now. And you can put him in whatever shirt you want to put him in, and you can put him in whatever suit you want to put him in, and you can keep the leg irons or you can take them off. But that's the exact same guy you're watching right now, is the one that shot Charlie Kirk from a couple hundred yards because he happened to disagree with his political beliefs. That's the same guy sitting in between his defense attorneys right now. And that's what the prosecutor is going to have to convince the jury. I think they're going to have a really easy job. What the judge is trying to do, and I don't want to depart from my colleagues, but if you have a security plan for the courtroom, why would you make it public? I mean, honestly, isn't that counterintuitive to have a security plan and then publicize it? I want the trial to be public because that's what Erica Kirk wants, and I defer to the victim and their family, but the security plan itself, it should not be public.
Yeah, well, that's what the judge is deciding right now in terms of what could be released from the audio transcription and the written transcription. I mean, in terms of, you know, the emotion and the reaction to the smirk that we saw just a little while ago. I mean, the things that the Turning Point USA employees, the Turning Point USA family, Erica Kirk and her family are going through, I mean, are really just incredible because every day they are facing threats. They're facing death threats. They're facing threats of violence. I mean, Erica Kirk is even keeping the location of Charlie's gravesite private. And here's the reason why she says that. Listen here.
We will be building the most beautiful memorial for my husband at Turning Point USA, and it will be for the world to see. But can I have one thing? Can my babies have one thing where we hold it sacred, where my husband is laid to rest, where I don't have to be worried about some secular revolutionary coming and destroying my husband's grave while my daughter is sitting there praying? One thing.
You know, I don't know any other court case that I can think of where you see the level of rhetoric and the threats of violence going on as this one has brought forward.
Yeah, John, my heart continues to go out for the victims of crime. They're the ones who are lost in this. And Charlie Kirk, you don't see his image in the courtroom, and you actually don't see his family and his friends in the courtroom. It's all about the defendant. You know, you played a clip earlier on where Erica Kirk was almost crying out for someone to explain to her what is going to happen. And I made a note to myself, as soon as I get off this show, I'm going to go through mutual friends and say, you can call anytime you want. Call Turley, call McCarthy, call me, call anyone, and we will demystify this system. But what really has her bothered is what has me bothered, John. People have figured out how to monetize fear and anger, and now they have monetized insanity. Some of the things that that young mother has to put up with that are being perpetrated by people who make money off a podcast by spewing insanity, you are re-victimizing someone who's already lost her husband and the father of her children. I hope to hell you're proud of yourself for making money off of that widow's grief by perpetrating some of the most outlandish frauds I've ever heard in my life. Congratulations, you figured out how to get really rich, causing additional grief and harm to people like her.
Yeah, we pray for her and we pray for her children. They have been through so much, Trey.
Thank you.
All right, so the court going into closed session now. Will they take up whether or not they should release portions of an audio transcription of a hearing that took place on October the 14th, and then a written transcription of the hearing on October the 24th, both of which have been under seal, which, Sandra, leads to a lot of what people are complaining about, and that is after we had the avalanche of information about the arrest of Tyler Robinson, everything else seems to be under a blanket of secrecy.
Yeah, indeed. Let's bring back in our panel now, Josh, Donna, and Jonathan. Donna, your thoughts as you've been covering this from the very beginning on what has transpired so far and sort of bring our viewers along with what's happening right now.
Well, I think right now what we're seeing is this kind of push and pull between what is going to be weighed as more important. Is the judge going to rule that the transparency of the public and the media and everyone knowing what's going on there going to outweigh what potentially may be a risk to Mr. Robinson getting a fair trial? I do think that in our world today, and I've said this often, the court system and our laws don't really keep up with technology and media and things that are happening very fast. And it's really difficult to be able to weigh those things out to determine whether or not Mr. Robinson will be able to get a fair trial if certain pieces of information are revealed to the public, as we're now seeing in Mangione as well, that those are issues that are being brought to the court's attention. So I think the court's job is to make sure that they allow for as much transparency as possible and give Mr. Robinson the ability for his due process and to have a fair trial and to be able to find a jury pool that will be able to be fair based on what they hear prior to this case coming forward. Now, anything that they're going to bring out at these hearings most likely is going to be evidence in a trial that a jury would hear. Of course, if there's motions to suppress that evidence, that may raise this issue again before the court. But I do think that the court is going to take it seriously, and I do think he will err on being more transparent than not.
I thought it was interesting that Judge Graff ruled that members of Tyler Robinson's family would not be allowed to stay in the courtroom during this hearing into what will be released. Brett Tolman, who's with us, and we'll see him in just a little while, said, well, that could be potentially because some of the family members may be called as witnesses. And Josh, if they were privy to everything that was aired in those hearings, what could the potential effect of that be?
Yeah, that's always a concern. You want to make sure that whoever's present in the courtroom isn't potentially going to be a witness later on, and it might cloud their testimony. But the other thing I think we're learning about this judge is it's remarkable to me, every time we've seen him in court, how conscientious he is, how deliberate he is. He always seems to have his remarks prepared. And I think that we see the same thing today in the way that he introduced what they're going to talk about today, and how deliberative he is about all of this. And as far as this first hearing, I think the concern is primarily about courtroom security. That's why it was put under seal originally, and why the transcripts and the recordings have not been released, because it has to do with courtroom Security, I could see him keeping that under seal because of that reason and because it doesn't really have to do with the facts and circumstances of the case. But I agree with Donna that I'm hoping today, and I think it might be an indication by the judge allowing for him to dress down in civilian clothing and not have cameras picture him shackled, that is an indication that he will lean towards allowing cameras in courtroom, because I think the transparency of this case is so important. We saw in the lead up to this hearing, Erica Kirk talking about conspiracy theories and misinformation that is out there. And the best way to fight that is allow cameras in the courtroom so people can see exactly how justice is being served.
Jonathan, your thoughts on what has transpired so far?
Well, I think that Judge Graff is handling this exactly as he had to. Many of us have been advocates for greater television coverage within these courtrooms for literally decades. And the rule against it is rather dated. Now, it's true that in these preliminary hearings, we expect that much of those hearings is going to be redacted. The cameras will be turned off. If you're talking about the suppression of evidence, you're probably not going to want that to be aired widely to a potential jury pool. But that has never been a serious problem. We've all seen coverage of trials. Judges have been quite nimble in this respect in determining whether witnesses can be shown or not shown, whether certain arguments, particularly in pretrial, will be made public. But the real question for Judge Graff is, are you going to make this trial available to the public? The framers felt very strongly that trials should be public. And that is reflected in the Constitution. And the reason that they felt that way is unfortunately being borne out with Erica and her objections, that the best way to avoid misunderstandings is to expose any governmental abuse, to expose what occurs in these cases, is for the public to be able to see it with their own eyes. And instead, if you have this lack of transparency, you have these contemptible conspiracy theories that spring up, particularly now on the internet. And this is a way to combat that, to allow greater transparency for all parties involved.
All right, good thoughts, Professor Charlie. Jonathan, stand by. Donna and Josh, stand by too, because we want to bring in Brett Tolman. He's the former U.S. Attorney for Utah, also the Right on Crime Executive Director. Brett, good to have you with us. Good observation with the judge potentially excluding the family because they may be called as witnesses at a future point. In terms of the coverage of this trial and transparency, Erica Kirk has a couple of different reasons. One is all these conspiracy theories that are out there and whether or not people from Turning Point USA were somehow involved. And then the other is almost kind of like an eye for an eye. Listen to what she told Jesse Waters back on the 5th.
There were cameras all over my husband when he was murdered. There have been cameras all over my friends and family mourning. There have been cameras all over me, analyzing my every move, analyzing my every smile, my every tear. We deserve to have cameras in there. Let everyone see what true evil is.
So she's making the point that everything about her husband's assassination was very, very public. Why should the man accused of perpetrating it be shielded from public view?
Well, she makes an incredible point. I mean, the reality is what we're analyzing, John, is can you preserve constitutional protections, due process, and a fair trial with cameras in the courtroom? And I'm afraid that the old arguments don't really apply. The strongest argument that many have argued is, well, it turns it into a circus. You have lawyers that want to become actors and judges, and perhaps the O.J. Simpson trial was something that jades that view. The reality is, though, this is something that is needed in order to achieve justice, because you do have to have the public as part of this, and that's why you opened courtrooms. Jonathan Turley is absolutely right. They got contemplated opening the courtroom and for citizens walking in. They sat in the rafters and the galleys and everywhere else. They sat and watched trials occur. Now we have media that can accomplish that to a greater extent, and it needs to happen in this case.
Brett, Sandra here in New York, we're watching this tape playback on their screen right now of the moments before we heard from the judge. Tyler Robinson, 22 years old, sitting with his attorneys. And he appeared smiling and even laughed at one point. And Jonathan was making the point that, oftentimes you see this, the accused criminal separating himself, being able to separate himself from the crime. I wonder if you could just further weigh in on that, as you have obviously seen courtrooms like this many times.
Yeah, and Sandra, the thing that is so easily forgotten are the victims in the case. And so you work as a prosecutor, you work as a defense attorney, and it becomes your day in, day out. And let's face it, they're seeing a more human side to Mr. Robinson than the side that the victims in this case ever received or observed. And the rest of us, look, we saw it play out on television, live, the assassination of Charlie Kirk. It's the prosecutor's role and the judge's role to never let that be forgotten while he's being tried. The decorum, the seriousness of what's happening. It's not surprising to me to see somebody that was so brazen in what they did in murdering Charlie Kirk, that they then sit in the courtroom without what we would like to see, and that is a sense of remorse, a sense of regret, and that's just not going to happen during this trial.
As we pointed out, Brett, at the top of this, as we were introducing you, that you were the former U.S. attorney in the state of Utah. Is there anything peculiar to Utah law that people should be waiting for here?
Well, one thing that is peculiar is Utah is at the discretion of the judge in terms of how much publicity or how much openness and transparency. A lot of states have adopted policies that can basically take that decision away from the judge.
All right, let's bring back in Donna Rotuno, Josh Ritter, and Jonathan Turley. Donna, let's start with you. To Brett's point about the smirk and the demeanor and the way he's comporting himself, the fact that Catherine Nestor did not, or maybe she did and he just didn't follow it, say to Tyler Robinson, no emotion, no smirk. There is a large part of the country will be against you if you're seen doing that in court.
Yeah, for sure. And as a lawyer who sits at those tables all the time, I have those conversations with my client, whether there's cameras there or not. There's always people watching you, whether it's the jury, whether it's the courtroom personnel, the judge, the prosecutors, anybody that's there watching. So it doesn't even need to be a camera for you to have that conversation. Now, maybe she had it, maybe she didn't. And, we also have to remember, we've looked at him in a very small window here while he's in conversation with his lawyers, and I will not make any apologies for him, but what I will say is I think we have to give him a little bit more time to see how he comports himself rather than just the very small snippet we saw while he's in the middle of conversations. And it is also Ms. Nestor's job to make sure that she keeps him not only appropriate, but calm and engaged. And so there's a lot of conversations you have with the client. You saw her put her hand on his arm twice. I mean, her job is to try to humanize a person that the world is looking at as a monster. And so she's in a tough position. And I think that, we will see him be respectful to the court. We'll see how he comports himself moving forward.
Very interesting analysis there. Jonathan, your thoughts?
Well, I agree entirely with what Donna said, and that is an important point for the defense. One of the challenges of the court on the subject of these hearings is how do you really protect publicity in a case that has the whole world watching? It's like, you're throwing a towel to a guy swimming in the ocean. I mean, the fact is, this is saturating every channel. Every newspaper is covering this in depth. And so you're going to have publicity there. What the judge can do is not necessarily keep cameras out, but Trey is correct. You want to keep some things out, like obviously the security plan, but also some of these suppression hearings. You don't want evidence that is being suppressed to be widely distributed before a jury is seated. All those things can weigh on a court, but we can do that. We've done that. And also, I think that you can trust the media. I've been very impressed. The media follows the rules of these judges. They position the cameras so that they're actually often shooting away from the jury, so you can't see the jury. They often do not show witnesses if that's the judge's request. There's lots of ways to protect these interests.
So, Josh, you've been through a lot of these, as Donna has. How do you see this all unfolding in the days and weeks ahead?
Well, hopefully we're going to get a ruling today on the issue of whether or not he's going to allow cameras in the courtroom. That to me is very significant. And I know we talked a little bit about it. You know, the cameras are really there to protect the anonymity of the jurors, but it's also there for the idea, as Jonathan was speaking to earlier, that our system is distinguished from the rest of the world because of its transparency. And part of our modern day transparency has to do with cameras. And so I hope that the judge will allow that moving forward in this case. But if I could just add to our comments about his demeanor in court earlier. You know, we talked a little bit about don't try to understand the mind of a monster. Well, we do know a little bit about the mind of this monster in that I believe he's incredibly proud of his handiwork. It makes us think a lot about Luigi Mangione. These two men inscribed notes on the bullet casings that they used to commit murders, murders that were to send a message. He committed an assassination in a very public place against a person that he had ideological differences with, entirely politically motivated. That is a person who's proud of their handiwork. So I think that when we see him loose and calm, relaxed, and smiling in court, I think that's an outer manifestation of his inner feelings that he is very proud of what he's done, stands by what he's done, has no remorse for what he's done, and is looking forward to the world watching.
Jonathan, I see you nodding in agreement.
Really troubling.
Yeah, I think that's exactly right, as Josh put out. When you have cases of this kind, you are off the map. You are where monsters dwell, to use pirate terms. This is where you find monsters, are in these cases. And you find people that don't think the way you do. This is one of the reasons jurors often stare at defendants whenever they can get away without being impolite. They look at these defendants to try to figure out something not just about them, but themselves. How can someone go off the map to this degree? The evidence here is overwhelming. And a lot of attention is likely to be what possesses a person like this to treat someone like Kirk as a trophy. And that is what happened.
It's just
well, if it's true that he did it and he gets convicted of it, I guess you could say that, you know, he thought in his own twisted mind that it was something that he needed to do, and you could never understand, as you were pointing out earlier, Professor, you know, Trey was pointing out, you know, the person who drowns their children and the person who bludgeons someone to death, you could just never get inside that mind to even begin to understand what's going on.
That's right. I think that's absolutely true.
Yeah, that does it for us here.
Let's bring in now Jonathan Turley, George Washington University law professor and a Fox News contributor. Jonathan, good to have you jump in here and give us your expertise and how you're reading this moment. You know, we haven't even gotten to the actual trial portion. This is just the things that come before, but this is a very important part of it, right? Media access, being able to see him. This is the first time we're seeing him. We already see parts of him that have stunned us. You know, he's smirking, he's smiling with his defense team. It's telling us a little bit more about this man.
It is. And what you have to keep in mind is what this judge is trying to accomplish here. He has to impanel a jury. And that's going to occur in a case that is saturated in the media, where every newspaper, every cable station is just echoing all of the day's developments in the case. And also keep in mind that when you talk about doing justice to the victim's family, one of the things the judge is trying to accomplish here is to make sure that there are not any reversible errors. That is, yes, the evidence in this case looks overwhelming. Now, he's still to be proven guilty. There's a presumption of innocence. But even in a case with overwhelming evidence, you can have reversible errors. And that just further victimizes the family, puts them through this again. So the judge is trying to make sure that he's being very faithful to where these navigational beacons are. I've been very impressed with this judge so far. I've been impressed with both teams of counsel. They're all doing their job. This has been a really good start to this case. So my view on this is that he should allow cameras into the trial. That we've done that many, many times. This idea that you have to keep cameras out of trials, I think, is rather archaic. There's lots of ways to protect the identity of the jurors. The cameras are often positioned so that they're staring away from the jurors, at times next to or behind the jurors, so you can't see their face. You can protect the identity of witnesses. You can cut off the camera when you're talking about evidence or other things the judge doesn't want. So I'm hoping that he'll reach a middle point here where he says, yes, we're going to televise as much as we can. We're obviously not going to be televising security plans. We're not going to be televising suppression hearings. But I'm going to allow it to some extent because all crimes are crimes against the public. That's why the people prosecute. But a political assassination is a particularly heinous crime. And I think this judge realizes the public needs to know and see justice being done here.
And I think you're right that he's already displayed that fairness in, removing the parents and the family from today's hearing. They wanted to be there with their son. They wanted to support him, and he removed them because he didn't think that that would be fair to the prosecution, but also, this family might come up later as potential witnesses.
That's right. I mean, you can't really lower your guard as a judge because an errant ruling can end up contaminating evidence or compromising witnesses. The key is on the prize here, to have a fair trial that gives the defendant all of his rights, avoids reversible error, and brings closure to the victims and to the public. This judge seems to be well on his way to do that. This is not an easy case because you can't even change venues in this case with any meaningful impact. It is a saturated media environment, so you have to sort of play that as it is. It's like complaining about the weather. This jury is going to know about this case. But you can try to control, for example, some evidence that you don't believe should be in the trial from being widely distributed that might contaminate that jury. So I think the judge is going to try to thread that needle. But even issues like security can be heavily contested. Defense counsel is often worried that if you have a lot of evidence of security in the courtroom around the defendant, it can portray the defendant as an immediate danger to the jury. And so even small details like that tend to be fought over by counsel saying, do we have to have this or that in the security plan?
Jonathan, stand by for us as we wait for the judge to return the camera inside the courtroom and let us know what is going on. If we get an update, hopefully soon.
Anytime without 7-6, State of Utah versus Tyler James Robinson. I note the presence of counsel that previously entered their appearances. We have come out of the closed session and concluded that business. However, the court became aware of an event that happened before. And my understanding was during the open portion of this hearing earlier that there was a violation of the standing decorum order as it relates to transmission of these proceedings. I want to hear from counsel, and then I will make a ruling concerning that shortly thereafter. Ms. Visser.
Thank you, Your Honor. I'm referring specifically to Rule of Judicial Administration 4-401.01. This gives the court discretion to terminate or suspend electronic media coverage at any time without prior notice, if the judge makes particular findings and that the specific circumstances warrant it. It is our position, the defense position, that there has been a violation of the decorum order. It is our understanding that those live streaming this signed and declared that they would follow the decorum order, and they violated it. So we are requesting a sanction. We believe these court's orders are binding and they need to be respected. We also believe that it threatens my client's right to a fair trial. It's the whole reason we filed a motion in the first place to remove his shackles. It's our understanding that his shackles are visible It is also our understanding that potentially some audio from council table was heard. We are definitely taking more measures on our own to ensure that that does not happen again. But there has also been some filming of computers and materials at council's desk. That's entirely inappropriate. And I think everybody in this room will agree that's entirely inappropriate. So we are asking for some remedial measures here. We're asking for it to terminate for today, and we can proceed after that.
Thank you, Ms. Visser. To the state.
Your Honor, the state, as stated earlier, we believe that the court's order was very clear, and if there has been a violation of that order, then we agree that there needs to be some measure taken. We'll leave it to the court to decide the appropriate response to that violation, but we agree that any violation of the court's order needs to be addressed.
Thank you, Mr. Ballard. To the press, attorneys for the press.
Your Honor, Jeff Hunt for the media interveners. This is the first time that we've heard about the violation. We've not had an opportunity to look at the video or investigate the audio or look at the capture of the computers. But filming of the inadvertent filming of the shackles, I did talk to the pool photographer. My understanding is that there was a zoom out shot that did inadvertently show the shackles. That was improper. That was inadvertent, and we apologize for that. They've taken measures to make sure that the pool video that is disseminated to the rest of the pool does not contain any capture of the defendant in the shackles. We can't do anything about the live stream, of course, but we can control what the rest of the video is that we capture and disseminate. So that is being done. The audio for counsel, my understanding is the only audio that they picked up was from counsel's microphones. I don't have any further information about that and whether that's a violation. Filming of the computers is not a violation of the decorum order. If the capture can show the document that counsel is looking at, then that is a potential violation. So I just don't know how much detail the shot is that is of concern to the court. But I'll just say that we reiterated as soon as I heard this from Mr. Ballard with the pool representatives that this is very important to follow to the letter of the court's EMC order. They understand their obligations. They take that very seriously. They're not perfect. Mistakes happen. We're trying to correct as much as we can on that. But we think termination is not an appropriate remedy. An admonishment from this court, a reminder that they need to follow to the letter the court's EMC order is appropriate. That's the message that counsel has delivered to the media representatives and the pool operatives, and we think that is the appropriate remedy.
Thank you. Thank you.
I just want to make it clear, we're still receiving messages that shackles can be seen on the live stream as we restart it. So it's still a problem.
Thank you. I appreciate all parties weighing in on this important matter. And I find that there was a violation of the standing decorum order that was in effect as of October 30th, 2025, based off what's been proffered, as well as the EMC order signed by the court. As previously stated by Ms. Visser, the court does have discretion in determining whether to terminate the broadcast of these proceedings. And again, if there's specific circumstances warrant such action, that the court would need to make findings in order to do so. I find that excluding the cameras from the courtroom would be disproportionate for this hearing. I find that making it very clear, first, that the transmission cannot begin until court is in session and must end as the court ends the session and cannot be filmed before or after. The filming of, as previously stated in the decorum order, EMC must be followed to the letter. The sanction for today is that this camera will be relocated away from defense table to where the bailiff is, where Jeff is standing over here. I want to immediately address any possible transmission of shackles, as previously stated by counsel, and remove the possibility of capture of screens of the computers at defense counsel's table as well. In addition, if there's further violations of the standing decorum order, this court does have the right and will exercise termination of broadcast of these proceedings. And I simply want to put all parties on notice, to the press, to all parties, that this court takes this very seriously. While the court believes in openness and transparency, it needs to be balanced with the constitutional rights of all parties in this case. As such, we will take a brief recess to allow the relocation of the camera and to the place indicated by the bailiff, and then we will resume these court proceedings. I am anticipating this take perhaps 5 minutes. All right, and then we'll come back on the record and handle the remaining of this hearing. I appreciate the patience of parties as we move forward. We are trying to do the best.
Let's reset how we got to today. Charlie Kirk was murdered on September 10th. 22-year-old Tyler Robinson was taken into custody 2 days later. This is the full list of charges he faces: aggravated murder, felony discharge of a firearm, 2 counts of obstruction of justice, 2 counts of witness tampering, a violent offense committed in the presence of a child. And if convicted, he could face the death penalty. But somehow all of that, well, it puts a smile on his face. Joining me now on today's hearing is Utah defense attorney and former prosecutor Nathan Evershed and criminal defense attorney and former prosecutor Imran Ansari. Thank you both for being with us here today. Imran, you're here with us in New York. Let's start with the hearing today on allowing cameras in the courtroom. What will the judge be analyzing? What will you think will be his decision?
Well, the judge is going to be analyzing whether allowing cameras in the courtroom will be prejudicial to Tyler Robinson. That's really the only thing that's going to be considered by that judge when making the analysis, and weighing that against this presumption of public access to our courts, which is embodied essentially in our Constitution, 6th Amendment, and also the 1st Amendment, where you have the public access with the press interest in covering this case. This is a hugely public case. You have the nation really interested in what's going on in that court in so many ways, and the real question for that judge is, if we allow the cameras into the courtroom, we allow the press to sit there, allow the nation and the world to see what's going on during the course of this trial, would that be prejudicial to this defendant? I don't think that's going to be a compelling argument for the defense, because they want those cameras out. Of course, the prosecution also saying that they may not want those cameras in there, but I don't think that they're going to be prevailing on that because of all this pretrial coverage out there, and I don't see the prejudice to Tyler Robinson if they allow those cameras in.
And describe for me very quickly, how does, for example, televising the pretrial hearings prejudice a potential jury against Tyler Robinson?
Well, I think the argument is that if the jury pool there in Utah are accessing some of these pretrial hearings, some of the rulings, seeing some of the evidence that may be excluded at the time of trial, that is the danger of the prejudice to Tyler Robinson. But we've already seen a lot of that, Will. We've already seen those text messages, so I think that they can't unring the bell.
Yeah, that's exactly right. Nathan, I want to bring you in now. You have deep knowledge of the state of Utah. We're talking about a juror pool in Utah. Imran and I were discussing, quite honestly, before we became on air, this case is everywhere. The evidence is everywhere. It's all over social media. For just an example, Nathan, people have seen things like this text exchange purportedly between Tyler Robinson and his roommate that shows the roommate asking why. And then Robinson says, "Why did I do it?" The roommate says, "Yeah, I've had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence." I have to wonder, Nathan, really at this point, if transparency isn't actually what's needed in this case, that a potential jury's already seen all of this.
Well, that's true. And what's going to happen is that it's probably going to be the biggest jury pool in the state of Utah history in order to cure some of that. Because while many of us are paying close attention to it, there are numbers of people that, well, might be aware of it, but don't know all of the evidence of it. And so there's nothing that a large jury pool can't really solve. And so it would just be, it might be well over 1,000 jurors or 2,000 that will be brought in, and then it comes down to 12 of them that would come in. So that would be, but that's something that the judges typically rely upon is, hey, jury selection is going to be intense. It might be well over a week. And eventually we're going to have to get jurors that don't really know much about the case or examine the evidence, because it would be prejudicial to him if the jurors have already examined the evidence, got conclusions, understand these things, and it'd be fairer for him and for the process to have a jury as fair as it could be.
I want to talk a minute about the defense tactics. We'll talk more a moment with both Imran and Nathan about excluding evidence. But let's presume for a moment that the evidence comes in, Nathan. You just described a jury pool of over 1,000. This is now a case that is not unlike Diddy or Luigi Mangione or O.J. Simpson. We're going to be talking about this throughout the hour here, a little bit more on Luigi Mangione. But this case is not simply taking place in a courtroom, Nathan. It's taking place out there in the world, in the minds of the public, as they consume a ton of information. If you're the prosecutor, do you feel confident that even with a jury pool of 1,000, you can find 12 who haven't already read something, maybe even an alternative theory about what happened in this case? Do you think you can find 12 impartial people in Utah?
I actually do believe that you could. I mean, there are a lot of people that are just normal, ordinary people going to school, trying to provide for their family, and they're not highly wrapped up into this thing. Obviously, everyone knows the case. Obviously, everyone has heard of it. But in terms of examining evidence, seeing the news reports and whatnot, you can find 12 in 1,000 to get to the most fair and unbiased jury that you can. It's not easy. It's going to be massive. But then the key from there is that all these individuals have family members or friends that have opinions, and it's going to be probably keeping the jury as insulated as possible during a very long trial. And that's going to be another issue.
They go home every night, Nathan, and they scroll their phones. It's impossible, I think, to sequester a jury today. So that takes us back to the other potential defense. So if you are the defense attorney, Imran, your first step is, I want to exclude as much evidence as possible. So you want to get excluded, for example, here's another example of a text exchange between Tyler Robinson and his roommate. How long have you been planning this? A bit over a week, I believe. I can get close to it, but there is a squad car parked right now. He's referencing the gun. I think they already swept that spot, but I don't want to chance it. Can this evidence successfully be excluded from the trial?
Well, we have to see if there were any constitutional violations here that the defense could hang their hat on to say, we're going to move to preclude this evidence, suppress this evidence, so it doesn't reach the jury. From what I know now, of the investigation, I don't necessarily see those constitutional arguments or having a foundation to bring those in. We may see more information, hear more information from the defense as we go along, and they may have a ground to say, all right, listen, these text messages, they were seized, they were taken from the phone, the electronics, in violation of the Fourth Amendment, search and seizure. But right now, if that's coming in, it's pretty powerful evidence, Will, that's going to be reaching that jury. And to go back really quick to what we were talking about, potential jurors who may have not heard about the specifics of this case, you have to be careful about those jurors, too. You've got to think, are they so insulated they don't know what's going on in the world? So when you're picking a fair and impartial jury, even the jurors who may be like, all right, I haven't read this story, I haven't heard that, you got to be careful about those people, too.
All right, Imran, Nathan, thank you both for the discussion.
Let's bring in now Paul Mora, retired NYPD inspector, attorney, and Fox News contributor, and Andrew Cherkasky, former federal prosecutor and criminal defense attorney. Thank you both for standing by with us as we wait for this to kick back into full gear. Paul, this is all about media access and whether or not cameras can be inside the courtroom. I know there's a lot of people across the country that want to see every single day of this trial. There's a lot of attention on this case. And now we know why the defense is pushing hard for there not to be cameras, because we saw Robinson for the first time, and we saw him sort of not looking remorseful at all, smiling, smirking with his defense team. And I believe that that's what they don't want the public to see.
Well, that could definitely be among the things that they don't want the public to see. Let's remember something else, Aisha, that the evidence that we know about at least is quite compelling. Despite all the ludicrous conspiracy theories that have gone viral online, the fact that they've got the gun, they've got the DNA, they've got the fact that he surrendered, statements that he may have made at that time, it looks like the case is quite strong. And let's remember that it's a death penalty case. So the stakes are very, very high. Both sides, but especially the prosecutors, want to make sure they don't do anything that could potentially imperil that case. But if you're sitting where the defense is, you would like a lot of this to happen behind closed doors because it could very well turn into a little bit of a media circus. I go back to the Koberger case. Remember what happened there? It looked like everything was going along fine. And then they granted to change of venue and they had to move the whole thing to another county, which caused a delay. So they, I'm sure, are aware of that. They don't want a repeat of that. But you're 100% right. I think you're right over the target here with him. He doesn't look very remorseful. And guys who do these things for ideological purposes, it's very often how they are. This is how they talk to the world. This is why they do what they do. And they want their moment in the sun to get their message across.
Andrew, get into the mind of this judge right now. We don't know a whole lot about him, but we know that certain things that he's done have benefited the defendant here. He's been allowed to wear regular clothing. Cameras are not allowed to capture video of him when he's handcuffed, when he's shackled. We can't see what he looks like when he's got those handcuffs on. So wouldn't that signal to the rest of us that perhaps the judge will balance that with allowing there to be a camera, or at least one camera, presence inside the courtroom?
Well, I think that it's going to be paramount in this case to have total transparency. It's easy to condemn those in the podcast sphere who are doing what I guess we could call conspiracy theories, but they're doing us a favor. They're doing essentially what the defense attorneys will be doing throughout this trial and ultimately in front of the jury. They will be trying to sow reasonable doubt. Those podcasters, Candace Owens, has no burden of proof in order to put something out there, and as hurtful and harmful as it may be to the emotions and those close to Charlie Kirk and so many others in the nation, they're doing, again, what these defense attorneys are going to do to start to put reasonable doubt out there. And in order to tune into these podcasts day after day, you have to assume there are some reasonable people. Are those the same types of people you're going to have on the jury? So I think ultimately, by being able to get publicity on this trial, to understand kind of what both sides of the aisle are saying, what the evidence is showing, there may have to be some evidence that's ultimately kept away from the public due to some sort of sensitivity of it. But there should be extreme transparency here.
Yeah, you both brought up Erica Kirk. This is what she said about those online conspiracies to Outnumbered yesterday. Let's watch.
My silence does not mean that I am complacent. My silence does not mean that somehow Turning Point USA and all of the handpicked staff that loved my husband and my husband loved them is somehow in on it. We are all grieving in our own way. And they are trying to find the answer to something that happened that was so evil. They are trying so hard. And I get that. We're doing the same. When you go after my family, my Turning Point USA family, my Charlie Kirk Show family, when you go after the people that I love, and you're making hundreds and thousands of dollars every single episode going after the people that I love because somehow they're in on this, no.
Yeah, Paul, she makes a really clear case as to why there needs to be media allowed to cover this step by step, day by day. You know, every single thing that happens inside that courtroom needs to be shared with the public because it directly impacts her family, it impacts her kids, it impacts Turning Point and the future of this organization. I wonder, you know, we saw the O.J. Simpson trial, okay, one of the biggest cases in that decade. This might turn out to be one of the biggest cases in this decade. Can't they figure out a way to do this fairly while still allowing the public to see what's happening?
They will. I think almost certainly there will be some media access for all of the reasons that you mentioned and that we've discussed, because people are aware of the fact that conspiracy theories, like mushrooms, they grow in the dark. And so you want to make sure you have as much transparency as possible so reasonable people can see the actual evidence and not stuff that comes out of the blogosphere where there's these theories that somehow or other there were foreign governments involved and all these other arabesque stories that make no sense. Aisha, listen, as somebody who's done all kinds of investigations, the idea that all of DOJ, FBI, the Utah authorities, Turning Point USA, they're all part of some vast conspiracy with whatever entity you want to conjure here. The fact that they're all acting in synchronization and all are keeping silent about it is crap. All right, I'm just going to cut to it. I'm sorry, I can't even entertain it for a nanosecond. It's not happening. Let the case be tried within the four corners of that courtroom. Let's see the entity and the evidence, and let's do it like a mature legal system does. And I have no doubt, by the way, that that's how it's going to go.
Okay, so we're still waiting here to see if court opens back up this hour as the judge deliberates, and we'll see if he makes the decision today. Andrew, do you think we'll get a final decision on cameras inside the courtroom today?
No, I don't think this is going to be an immediate decision. The judge is probably going to have to look through the brief some more and consider what the arguments are here. And I hope he considers the real good common sense, because as Paul is saying, this may be a slam dunk case, and Mr. Robinson may be a lone actor in all of this. But it is Erica Kirk who's pointing out that these kind of conspiracy theorists are profiting from what they're putting out there. Again, we have to go back to think about what the defense attorneys are going to do. What kind of theories can they come up with to get even one juror to hang a jury in this case? And we think about what is it that drives people to listen in and pay attention to what Candace Owens says every day, and why she has so many people helping her. That could be any one of the 12 jurors on this jury. So I think in kind of the closing up the case for the public, for the future of kind of where this storyline goes, is very, very important. And the only way to do that is to get the answers to, even if they seem like ridiculous questions, why are people tuning into it, and why is it wrong?
I think you brought up a really good point about how slow this case might go. If we don't find out today just about this tiny portion of this case, we can expect this case to drag on maybe for months and months. Paul, about that, we don't even have a plea deal yet. You know, not a plea deal. We don't even have a plea yet from the suspect. We haven't even gotten to that portion yet. Is the pace of this case, is this because of the death penalty is on the line? Is this why we're going to see this potentially go very slow?
Yeah, I think there's two things here. First of all, it's very high profile, so the attorneys are going to challenge it at every turn. We're seeing it as well in the Mangione case, okay? They're not going to take the easy route on this. Every stage of this, you're already getting motions to dismiss. They're going to lawyer this, as the term goes, at every stage. But then the overlay, as you mentioned, is the fact that it's a capital case. This is something that imports all kinds of different procedures under Utah law. So, yeah, this will grind slow, especially for a state case. But at the end of the day, you do want to make sure, despite the fact that everybody wants swift justice here, he's innocent until proven guilty. You want all to be adjudicated publicly as possible, so that not only do you forestall any appeals that could have any substance, but as we keep mentioning, in the court of public opinion, you want the issue settled.
I want to go through some of the evidence that we have, because we actually got a dump of evidence when this first all happened. And this is from the charging documents. This is Tyler Robinson and the detailed note that he left for his roommate, where he says where the document says, on September 10th, 2025, the roommate received a text message from Robinson which said, "Drop what you're doing, look under my keyboard." The roommate looked under the keyboard and found a note that stated, "I had the opportunity to take out Charlie Kirk, and I'm going to take it." Police found a photograph of that note. And then we have text messages too, Andrew, about why Robinson did it and the rifle that he was looking for afterwards. He text messaged with his roommate, who said, "Why?" Robinson replied, "Why did I do it?" The roommate says, "Yeah." And Robinson answers, "I had enough of his hatred. Some hate can't be negotiated out. If I am able to grab my rifle unseen, I will have left no evidence." And then, of course, that's where he gets caught by police. Andrew, these text messages are incredibly damning. What is the defense thinking right now before this trial even gets underway? How do they even begin to try to save him?
when you start thinking about how this evidence is going to play out and what the timeline and all of that is going to look like, I think that you have to realize Mr. Robinson himself happens to be the most in control of all of that. You know, what he's not doing here is coming forward like a Robin Hood would, I guess. If you're a vigilante, you come forward and you admit to it and you celebrate what you did. Well, he's just sitting there, I guess, smirking in a courtroom. But what he's really doing is he's going to, it seems, play this out with every technicality and every argument that you possibly can to see kind of what goes on between now and what appears to be the inevitability that he'll be put to death in a death sentence. If that doesn't happen, it's because something was fumbled along the way. Prosecutors weren't able to get certain evidence in. I mean, that's going to happen months down the road. Were all these text messages collected correctly? Is he in the right place? Does the GPS data show this? Can that get excluded somehow? And so they'll go through all those dances, and then they'll go through the appeals. And if the evidence is as it appears right now, it will be a losing case for him. But all of those questions over all that time will kind of perpetuate, and we won't know the full conclusion of this. It could be 8 years, 10 years down the road, even more sometimes, before people ultimately have their final appeals exhausted.
Paul, just wrap this up for us here. Just watching this video, the first time we're seeing him inside the courtroom, he's dressed, in a nice dress shirt. The defense attorney touching him a few times. He's smiling. They're smiling back and forth. I mean, just what do you make of this this afternoon and what we're seeing here play out?
You know, it can be difficult in these circumstances to play armchair psychologist, and we don't have a jury yet. You know, he's not in front of the jury that's going to decide his fate, assuming we get that far, which we likely will. So his demeanor at that point may be very different. But, I think Andy raises an important point here, and just to extrapolate on a jury selection here is going to be very, very important. That's always the case in any high-profile case. And all you need is one person who has been reading some crazy stuff, and you may be able to hang the jury. So they may clean him up when it comes game time, but he definitely doesn't seem very concerned. And just to extrapolate a little bit, maybe to go out a little on a limb, in cases like this where perpetrators are accused of doing something for a particular ideological purpose, very often they want the trial. They're not going to just plea immediately because they want their moment in the sun, as I said earlier. They want to get their message across. The courtroom becomes their stage. We've seen that many times in the past. So you have to import the possibility of that. But if you're sitting where his defense is, you would certainly like him to look a little more serious, a little bit more subdued. And that won't play very well to the court if he's smirking, looking around, looking disheveled. That's not what you want if you're sitting at the defense table.
Yeah. Andrew, Paul, thank you for joining us. Stand by as we continue to wait here for the judge to return and open the court back up.
Hey, everyone. I'm Emily Campagno. Catch me and my co-hosts Harris Faulkner and Kaylee McEnany on Outnumbered every weekday at 12 p.m. Eastern, or set your DVR. Also, don't forget to subscribe to the Fox News YouTube page for daily highlights.